Hello everyone, and welcome back to Money Finance Wealth. Today, we are building on a critical topic we've discussed before, estate planning, by diving into one of the most common and important questions people have. What is the difference between a will and a trust? Before we dive in, if you're new here, please hit that like button, subscribe to the channel, and ring the notification bell so you never miss out on our in-depth guides to mastering your finances. We're all about providing you with the knowledge you need to build a secure financial future. The terms will and trust are often used interchangeably in casual conversation, but in the legal and financial world, they are fundamentally different tools that serve distinct purposes. Choosing the right one, or, as is often the case, using them together, is essential for ensuring your assets are managed and distributed exactly as you wish. This video will demystify these two cornerstones of estate planning, break down their key differences, and help you understand which might be right for your situation. To understand the difference, let's first quickly solidify our understanding of a will. As we covered in our last video, a will is a legal document that primarily does three things, all of which take effect after you pass away. Names and executor. This is the person you choose to be in charge of carrying out your instructions. Specifies beneficiaries. It details who should receive your property. Appoints a guardian. For parents, it names who you want to care for your minor children. The most important characteristic of a will to understand for this discussion is its relationship with the court system. A will is essentially an instruction letter to the probate court. Probate is the public, court-supervised process of validating the will, paying your debts, and distributing your assets. A will does not avoid probate, it guides it. Now let's introduce the trust. A trust is a different concept entirely. It's not just a document, it's a fiduciary arrangement, which is a fancy way of saying it's a legal entity you create to hold title to your assets for the benefit of certain people or organizations. Think of it like creating a small private company. You transfer your assets into this company, and then you lay out a detailed rulebook for how the company's assets are to be managed and distributed. There are three key players in every trust: the grantor or settler truster. This is you, the person who creates the trust and transfers assets into it. The trustee. This is the person or institution, like a bank's trust department, responsible for managing the assets held in the trust according to the rules you've set. The trustee has a legal duty to act in the best interest of the beneficiaries. The beneficiary. This is the person or people who will benefit from the trust. They receive the income or principal from the assets held in the trust. Unlike a will, a trust is created and can be active during your lifetime. This is a fundamental difference. The two most common types of trusts are revocable and irrevocable, and their differences are crucial. The most popular type of trust for estate planning is the revocable living trust. Let's break down that name. Revocable means you, the grantor, can change it, amend it, or even completely dissolve it at any time while you are alive and competent. You maintain full control. Living means you create it during your lifetime, as opposed to a testamentary trust, which is created by a will after you die. In a typical revocable living trust setup, you play all three roles at the beginning. You are the grantor who creates it, the trustee who manages it, and the beneficiary who benefits from it. You manage your assets just as you did before. You can buy, sell, and spend them as you see fit. So why do it? The magic happens when one of two things occurs: incapacity or death. Incapacity planning. In the trust document, you name a successor trustee. If you become incapacitated due to illness or injury and can no longer manage your affairs, your successor trustee seamlessly steps in to manage the trust assets for your benefit. This can avoid a costly and public court process called conservatorship or guardianship. Probate avoidance. This is the big one. When you die, any asset that is titled in the name of your trust is not part of your probate estate. The will does not control it. Instead, your successor trustee takes over and distributes the assets to your named beneficiaries according to the trust's rules, privately, efficiently, and without court intervention. This can save your heirs significant time, money, and stress. To be clear, for a revocable trust to work, you must fund it. This means you must formally transfer title of your assets, your house, your bank accounts, your brokerage accounts, into the name of the trust. An unfunded trust is just an empty box. Now for the other main category, the irrevocable trust. The name says it all. Irrevocable means that once you create it and place assets into it, you generally cannot change or revoke it. You, the grantor, give up control and ownership of the assets. The trust is now the legal owner. Why on earth would anyone do this? For two powerful reasons. Asset protection. Because you no longer own the assets, they are generally protected from your future creditors, lawsuits, or judgments. For individuals in high liability professions like doctors or architects, this can be a critical tool for protecting their family's wealth. Estate tax reduction. For high net worth individuals, assets placed in an irrevocable trust are removed from their taxable estate. This can significantly reduce or even eliminate federal or state estate taxes upon their death, allowing more wealth to pass to their heirs. Irrevocable trusts are sophisticated planning tools. They are not for everyone and involve a significant trade-off. You lose control and flexibility in exchange for a higher level of protection. Let's put a will and a revocable living trust side by side to highlight the core differences. Effective date. A will only becomes effective upon your death. A trust is effective as soon as you create and fund it. Probate. A will's primary function is to direct the probate process. A properly funded trust completely avoids probate for the assets it holds. Privacy. A will, once filed with the court, becomes a public record. Anyone can see the contents. A trust is a private document. The details of your assets and who gets them remain confidential. Incapacity planning. A will offers no protection if you become incapacitated. A revocable trust, with its successor trustee provision, is a powerful tool for managing your affairs during incapacity. Cost and complexity. A will is generally simpler and less expensive to set up initially. A trust is more complex to draft and requires the additional step of funding it, making it more costly up front. However, it can save your estate far more in probate costs and legal fees later on. Control of assets. With a will, you own your assets directly. With a trust, the trust owns the assets, but with a revocable trust, you still control the trustee. This is a critically important question, and the answer is an emphatic yes. Even if you have a revocable living trust as the centerpiece of your estate plan, you still need a will. This special type of will is called a pour-over will. Here's why it's essential. It's a safety net. It's almost impossible to ensure that every single asset you own is titled in the name of your trust. You might forget an old bank account or acquire new property and forget to title it correctly. The pour-over will act as a safety net. It simply states that any asset in your individual name at the time of your death should be poured over into your trust. That asset will have to go through probate, but at least it ends up in the right place to be distributed according to your trust's wishes. It names a guardian for children. This cannot be overstated. A trust cannot name a guardian for minor children. The only legal document in which you can do this is a will. For parents, this reason alone makes a will absolutely necessary. Think of the trust as your main ship, and the pour-over will as the essential lifeboat that makes sure no one and nothing gets left behind. So which path is right for you? A will may be sufficient if you are young, have a relatively simple financial situation, don't own real estate, and your primary goal is simply to name a guardian for your children. A revocable living trust should be strongly considered if you own real estate, especially in multiple states, to avoid multiple probates. You want to keep your affairs private. You want to plan for potential incapacity. You live in a state with a costly or lengthy probate process. You want to make the process as simple as possible for your heirs. An irrevocable trust might be necessary if you have a very high net worth and are concerned about estate taxes, or you are in a high liability profession and need asset protection. This is an advanced strategy requiring expert advice. Choosing between a will and a trust and then drafting these documents correctly is a complex process with long-lasting consequences. This is not a DIY project for most people. The nuances of state law and the specifics of your family and financial situation demand professional expertise. Speaking of professional guidance, we'd like to thank Fenul Wealth Management for sponsoring this video. Creating an effective estate plan is a cornerstone of comprehensive wealth management. A financial advisor can work alongside an estate planning attorney to ensure your trust and will are funded correctly and work in harmony with your overall financial goals, from investments to retirement income. For more information, you can visit them at fenulwealthmanagement.com. Understanding the difference between a will and a trust empowers you to have a more intelligent conversation about your own estate plan. A will is fundamental, but a trust can offer powerful advantages in privacy, efficiency, and planning for incapacity. Often the best solution is a thoughtfully crafted combination of both. Thanks for watching Money, Finance, Wealth. We hope this video has clarified this complex topic for you. And before you go, please give this video a like, share it with your family and friends, and subscribe to our channel for more informative content on all things money, finance, and wealth. Your support helps us continue to create valuable resources for your financial journey. Thanks again for watching, and we'll see you in the next video.